Hello, this is Professor Harper with another lecture for Journalism in the Law. Today we're going to be talking about cable television. I'm not sure whether my able assistant, Sid the Great Pyrenees, is ready to rumble, but he may rumble through this lecture at some point. So, cable television is also regulated by the Federal Communications Commission, but not as much as what's known as over-the airwaves television. That's your CBS, ABC, NBC, your basic package on cable, which existed before cable television. So in the mid 1950s, cable community antenna television, or CATV, was the predecessor of cable television, and at first, the FCC refused to regulate cable television despite pressure from traditional broadcasters, ABC, CBS, NBC. But in 1962, it determined that it would regulate cable because it involved interstate communications by wire. In 1968, the Supreme Court upheld the FCC's decision to do this in a case United States versus Southwestern Cable Company. Essentially, what the desire was to make initially was to make channels available to public government officials and school administrators. These were referred to as PEG, Public Education and Government. And essentially the cable stations, in order to operate, had to provide equipment for those who wanted access to cable stations that were not in use at the time. And the U.S. Supreme Court did find that the FCC had exceeded its authority by forcing the cable television outlets to do this in a case that was FCC versus Midwest Video in 1979. Now, what happens with cable television is that rather than licenses that are held by a corporation like ABC, CBS, the cable franchises are agreements with cities and towns, and it essentially creates a virtual monopoly. In a place like Philadelphia, essentially you only have two cable providers, Verizon or Comcast. You can also go to Dish Network, but that's not a cable outlet, that's satellite television. And in 1984, the Supreme Court found that the FCC, not localities, had the power to regulate cable, but mainly from a technical standpoint. And that happened in capital cities cable versus CRISP. So in 1984, the Cable Communications Policy Act came into play, and it deregulated cable and allowed expansion, so that cable operators were allowed to determine the prices that were charged. And it also limited fees that local franchising authorities could charge the cable companies, so that the city of Philadelphia could not charge an incredibly outrageous fee. In 1992, the Cable Television Consumer Protection and Competition Act rolled back some of the provisions of 1984. So we saw this same thing going back and forth with broadcast television. And it regulated the rates that cable companies could charge to consumers. Now, we pay a lot of money if you have cable. I don't. I canceled it many years ago. When it comes to this Consumer Protection Act, it essentially forced cable to carry certain broadcasts or retransmit material, so that it was forced to broadcast ABC, CBS, NBC, Fox News, that type of thing. In 1996, the Telecommunications Act, which we saw in broadcast television, essentially focused on increased competition. So it allowed telephone companies, and this is where Verizon and Comcast got involved, and cable companies to enter each other's business. Okay, and as a result, mergers resulted. So the idea was to increase competition, but it actually increased the concentration of cable and telephone outlets. In 1986, the Supreme Court found in Los Angeles versus Preferred Communications that cable operators engaged in aspects of speech that were similar to newspapers and book publishers, so that this allowed cable to provide pornography on cable outlets, whereas on ABC, CBS, NBC, Fox, those types of stations could not have pornography. That is why HBO can run Game of Thrones. And the idea here is that you are paying for a service, and therefore you need access to that. You are granting the cable operator's ability to bring pornography into your home, and that you're also over the age of that you're 18 or over. And in 1991, the Supreme Court found in Leathers v. Medlock that cable engaged in free speech under the First Amendment. So there was First Amendment protection. In 1994, in Turner Broadcasting versus the FCC, the Supreme Court held that the First Amendment applied to cable in two ways. The government regulation of content was difficult, and so therefore the burden of proof was on the FCC, or what we've talked about before, strict scrutiny, so that the government had to provide the proof that the content was obscene, was indecent, or whatever, rather than the government bringing a case against the cable operator, and the cable operator had to prove why this was okay. And also that government regulation of material other than content was much easier, such as the structural rules of governing the industry. So there were really two things here. In the Turner Broadcasting case, the Supreme Court found that although a daily newspaper and a cable operator both may enjoy monopoly status in a given locale, the cable operator exercises far greater control. So a cable operator, unlike speakers in other media, can thus silence the voice of competing speakers with a mere flick of the switch. Okay, so it recognized the power of cable television. But prior restraint and post-restraint remain for obscene and indecent material. So that although pornography is allowed on is allowed on subscription table, there is restricted access on broadcast television between the hours of 10 p.m. and 6. It can only occur between 10 p.m. and 6 a.m. So there are some non-content regulations from the Federal Communications over cable television, so that local franchise authorities regulate pricing, as I said before, which includes the broadcast outlets and also public access channels, and the cable operators set the rates for the what's called the cable tier. CNN, MTV, TBS, and ESPN, and then there are premium channels like HBO, Showtime, Cinemax, and pay-per-view, which are not regulated. So three tiers. There's one basic, there's one cable tier, which is normally in your cable package, and then the premium channels. Now, broadcast television were prevented from owning cable, or in the so-called cross-ownership rule, in 1970, but in 2002 the U.S. Court of Appeals in D.C. eliminated the ban. So therefore MSNBC, which is a broadcast outlet, can own and run the cable outlet of MSNBC. There have been attempts to limit cable operators' ownership, but generally they've failed, so that Comcast, Time Warner, Verizon, and Cox control more than 60% of all the cable outlets throughout the United States. So what's important here is to and it's kind of hard because we use these terms kind of interchangeably, but there's one bucket which is broadcast television. Read ABC, CBS, NBC, Fox. Okay, there are cable operations and channels. Read ESPN, MSNBC, and then there are cable operators, which are generally local individuals or corporations, and then the relationship between the cable operators and the licenses and agreements goes between the cable operator and the city in which it operates. Okay, that's different from broadcast television, where KYW, for example, needs to get its license to operate from the federal government. So may seem a little bit confusing, but just think broadcast television, cable television. Two different things, even though they come to your television generally through the same route. Different forms of agreement. Television station has a relationship with the federal government and the FCC. Cable operators have a relationship with the FCC, but only when it generally comes to technical issues. And most of the relationship is between the cable operator and the local city or town in which that cable franchise operates. So there you have cable television, and thank you very much, and we'll see you online. And we all can thank Sid for his great contribution to this lecture. Thanks.